Thank you all for being here on this really warm, sunny day, and you're choosing to come to our book launch and book discussion of Judy's absolutely brilliant book, Constructing Modern Slavery: Law, Capitalism, and Unfree Labour, which has been published by Cambridge University Press this year, and it is available open access. So that is really quite wonderful because it's truly an incredible book which kind of traverses several disciplines and scales of law, which is, I think it makes the book very unusual. So I'm Prabha Kotishwaran, for those of you who don't know me, and I'm a professor of law and social justice here at King's. And so we are joined today by Judy herself and three brilliant, wonderful scholars who are leaders in their own fields, who will be reflecting and offering comments on Judy's book. So unfortunately, we don't have Parusha Chandan with us, who's also a colleague of mine here. She's professor of practice of modern slavery law at the law school, but unfortunately she's not well, so she's not here with us today. So what I'll do is very quickly introduce our speakers and then hand over to Judy to speak about the book. And then our readers will reflect on her book. And Judy will have a brief moment to reflect on their comments, and then we will open it up to all of you for Q&A. So Judy, it's very hard to actually introduce Judy. She's professor of labor studies at McMaster University in Canada. And she first studied philosophy, which I hadn't known, and then turned to law, thankfully.
Don't like abstraction.
And she's had a very distinguished academic career. She was professor at Osgoode Hall Law School. She was then at the University of Victoria and then at the University of Kent at the law school, and is now at McMaster. But in between, she was also a visiting professor and fellow at several universities and institutes. So she was a visiting professor at the Institute for Research on Migration, Ethnicity and Society at Linköping University in Sweden, and the Norma Research Environment at the University of Lund, again in Sweden. She was also Broadwell Fellow at the European University Institute in Florence. And in 2014-15, she was a fellow at the Institute of Advanced Studies in Nantes in France. And in 2018, she was at the University of Berlin. So in 2013, she was also elected as a fellow of the Royal Society of Canada. In 2014, she received an honorary doctorate from the Faculty of Law at the University of Lund. And most recently, she's been nominated for the Bob Heppel Award, or been awarded, not formally yet, but has been announced as the winner of the Bob Heppel Award for Lifetime Achievement in Labor Law.
I'm old.
No, you've achieved a lot by the Labor Law Research Network. And this will be awarded to her in person in July 2025. So, and Judy's work also spans several years of research on varied topics in labor law and sort of allied disciplines. So she takes a social legal approach to studying work in labor and is truly interested in a multidisciplinary approach to understanding the challenges that face workers. And her initial research was on Canadian labor law, history, and precarious work. And more recently, she's been working in the area of labor and migration, but she's also written on citizenship at work and feminist approaches to labor law. And not only that, she's also an activist in some loose sense. She's worked with women's groups, with trade unions, with legal clinics, as well as the ILO. So we're truly fortunate to have her come and speak to us today about, so I think the book is really a reflection of this very rich experience of activism, of academic work, and research spanning several disciplines. So thanks for being here, Judy. Now we have our readers of Judy's book. So we have Dr. Alessandra Nizadri, who is a reader in global development and political economy at the School of African, School of Oriental. Yes, I wanted to forget Oriental and African Studies. Yeah. So Alessandra has written also several books. Her first book is called The Sweatshop Regime, which was published in 2017. She has also edited two books, Marks in the Field, as well as the Handbook of Research on the Global Political Economy of Work. She's currently writing a book titled Cartographies of Social Reproduction and Global Development as Social Fabric. So we're really looking forward to the book and to your comments on Judy's book. So we also have with us Professor Olga Martin Ortega, welcome, who is Professor of International Law at the School of Law and Criminology at the University of Greenwich. And we are really delighted to have an international lawyer amidst us. So she's published several books. She has a book on international law, and quite importantly for the topic at hand, and I think she's rare for this, she's written a book on public procurement and human rights, opportunities, risks, and dilemmas for the state as buyer. And this was published in 2019. And she's also written a book called War, Conflict, and Human Rights, Theory and Practice. And last but not the least, we have Dr. Jovanovic, who is present with us virtually, who is a research fellow in business and human rights at the Bonavero Institute of Human Rights. And she's also co-investigator on behalf of the Institute to the AHRC-funded Modern Slavery and Human Rights Policy and Evidence Center. So she's a human rights lawyer, which is also great to have that area of expertise here. And she's the author most recently of a book by OUP published in 2023 called State Responsibility for Modern Slavery in Human Rights Law. So without wasting any more time, I'll turn over to Judy, who will walk us through her lovely book.
Great. Thank you. I'd like to begin by thanking Prabha for her inspirational work on human trafficking. It really is inspirational to me. And for organizing a panel of like my dream discussants, people whose work I follow and admire. And for the discussants for coming and reading the book, and for all of you for attending. Especially for all of you for reading and attending, because writing this book was a long and lonely endeavor. So I'm very happy to be able to discuss it with you. My initial focus was on how different forms of unfree labor and labor exploitation came to be seen as modern slavery, and why a labor law approach, one that talks about unions and public inspectorates, was a better way of dealing with the problem instead of using criminal law, which means prosecuting people and putting them in jail. But I hit an impasse. As a feminist who studies what the law treats as labor, I felt I needed to discuss sex work and its relationship to unfree labor and modern slavery. But most of the literature on human trafficking and modern slavery treats labor and sexual exploitation separately as ontologically distinct, even though many forms of work are exploitative, and gendered forms of exploitation, which include violence and sexual harassment, permeate many occupations, domestic work, garment work, and agricultural work, for example. My challenge was to find a way to discuss sexual and labor exploitation and the different governance strategies associated with them without treating them as essentially different or becoming mired in what I consider to be an unhelpful debate about whether commercial sex work is exploitative. Yes, it is. It took me a while to figure out a way out of this dilemma, this deadlock, which I did by treating the distinction between labor and sexual exploitation as an artifact of law and governance. This solution gave me the clue to approaching modern slavery as a construct of law and governance, hence the title of the book, Constructing Modern Slavery. I want to be clear, my adoption of a socio-legal constructivist or constitutive approach does not mean that I think that labor exploitation and labor abuse are not real problems and that individuals are not harmed by a range of abusive practices. Indeed, they are real, urgent problems and they should be addressed. But I argue that labeling these practices as instances of modern slavery does not help to eradicate them. In fact, it may do the opposite. Today, I want to briefly sketch what animated my book, my approach or method, its key concepts, its scope, and my overarching argument, and end with the specific questions that the book addresses. Modern slavery is an amalgam of legal concepts defined in international law: slavery, forced labor, human trafficking, and domestic servitude. What unites these concepts is a shared characteristic: They're all forms of unfree labor. One person deprives another person of their freedom for profit. My book explains how modern slavery's legal expression, how it is defined in law, and the legal domains and jurisdictions to which it is assigned shapes what we see when we see modern slavery and how we go about getting rid of it. It does so by providing a legal genealogy of modern slavery, by tracing the evolution over time from the mid-1990s to 2022 of its legal concepts and how they came together under a single umbrella. The book grew out of my puzzlement with developments in the United Kingdom. When I moved to the University of Kent in 2013, I encountered a lively debate about how to define and combat modern slavery. In Canada, where I had been living and working, modern slavery was occasionally used as political rhetoric to vilify instances of extreme exploitation. I was, however, familiar with the term unfree labor, used as an analytic concept for work relationships in which direct physical, political, and legal compulsion is used to acquire and exploit labor. In the UK, modern slavery became a quasi-legal concept with the enactment of the Modern Slavery Act of 2015. This act combines wide-ranging, and we're talking wide-ranging criminal prohibitions against human trafficking for sexual and labor exploitation with business regulation designed to create incentives for large transnational corporations to eliminate slavery in their businesses and supply chains by requiring them to be transparent about their efforts to do so. I was really curious about how modern slavery came to be the predominant legal lens for characterizing unfree labor in the United Kingdom. I traced the origins of the Modern Slavery Act to the United Nations Protocol to prevent, suppress, and punish trafficking in persons, especially women and children, which was adopted in 2000, which really meant I had to learn all this human trafficking literature. While doctrinal legal scholarship is essential for identifying the origins of modern slavery's legal components, its interpretation, and its application, it can't explain why a specific definition was crafted or why it was lodged in one legal domain, human rights, for example, instead of another, criminal law. To answer these questions, I had to move from legal analysis to study the social world. Researchers in political science and sociology have shown that how the problem of modern slavery is framed influences the different legal domains, criminal law, human rights law, immigration, or labor law, for example, is selected to address it. Frames are the mental structures we use to make sense of the complex totality of our empirical world. They are the often unconscious constructs that shape the way we see the world. They tell us how different pieces of information connect, what is right and wrong, and suggest solutions to correct perceived wrongs. I argue in the book that how a country filters international norms and approaches through its distinctive cultural, political economy frames a problem and its governance strategy. Cultural political economy takes the cultural or discursive turn seriously while still adopting a materialist analysis. Follow the money, look for power. This approach is helpful for explaining how countries frame the problem of modern slavery. Here I drew on the critical modern slavery literature to place key legal concepts in their cultural, political, and economic context, and to trace their use and evolution over time. However, when it comes to translating these frames into law, key legal concepts like jurisdiction matter. Jurisdiction is not simply a technical matter to be dismissed by political economists and sociologists, but instead it is a productive and distinctively legal technology with two related and often intersecting dimensions. The scalar dimension of jurisdiction is the most familiar. For example, the treaties that make up the European Union allocate governance authority or competence, or what I call governance jurisdiction, on a scalar basis between European Union institutions and member states. But jurisdiction has another important meaning. It refers to the power of the law to act and the scope of a legal institution's authority in relationship to other institutions. This is the governance dimension of jurisdiction. By combining the governance and scalar dimensions of jurisdiction, Mariana Valverde treats jurisdiction as a legal assemblage that operates as a kind of sorting mechanism that allocates a problem, a particular form of unfree labor, for example, to an authority for resolution. Jurisdiction establishes which state has the legal authority over a particular issue, whether the delegation of authority to other systems and apparatuses is lawful or unlawful, and which of the different subsystems or domains within the legal system and its institutions, a criminal court, a human rights tribunal, for example, has authority over a specific matter. Modern legal systems are a quilt of distinct legal domains, such as criminal law, commercial law, and constitutional law. Each legal domain or governance jurisdiction involves assumptions about the nature and causes of a problem and the goals, strategies, and techniques for governing it, including burden of proof, remedies, operatives, and forms and processes of adjudication and dispute resolution. By assigning a problem to one of the legal domains that makes up a legal system, jurisdiction settles the political question of how it is to be resolved. If, for example, human trafficking is seen primarily as a problem of criminal activity, then the criminal law jurisdiction is set in motion. Criminal law is replete with its own focus, the guilt or the innocence of the perpetrator. Principles, innocent until proven guilty. Precepts, proof beyond reasonable doubt. Technicalities, the rules of evidence. And officials, police, prosecutors, and courts, with a range of powers: search, arrest, confiscation of assets, and in some jurisdictions, of course, murder. By contrast, if human trafficking is regarded primarily as a matter of human rights, the institutional goal is to safeguard the rights of victims of trafficking from infringement by state authorities and practices and policies. The prevailing legal norm is to preserve human dignity, and states are required to develop mechanisms to identify victims and offer them redress. The relevant institutions are human rights agencies and tribunals that exercise administrative powers. The legal assemblage of jurisdiction operates in this way as a sorting mechanism that allocates the problem, domestic servitude, sexual exploitation, for the authority for resolution, and keeps the different domains from clashing. By bringing the legal and social political literatures into conversation, I tried in the book to show how cultural, social, economic, and political context shapes legal meaning, and how legal concepts and technicalities, in turn, shape how we see the world. Modern slavery covers a wide range of different kinds of exploitation, including sex trafficking, child sex trafficking, forced labor, forced marriage, the compelled sale of organs and body parts, debt bondage, domestic servitude, and the unlawful recruitment and use of child labor. My book focuses only on a subset of modern slavery: forms of unfree labor associated with international labor migration and transnational supply chains, for two reasons: to offer insight into the relationship between unfree labor and capitalism on the one hand, and to explore how sovereignty is being reconfigured under neoliberal global capitalism on the other. The discovery of modern slavery as a global problem both coincided with and reinvigorated debates about how to conceptualize unfree labor in relationship to capitalism. Whenever I think about capitalism, I need to take a drink of water. Historically associated with pre-capitalist forms of economic organization, unfree forms of labor, such as chattel, slavery, indenture, debt bondage, and servitude, were regarded as the antithesis of free wage labor. According to prevailing economic wisdom, unfree labor was supposed to disappear as capitalism deepened and expanded. Recently, however, unfree forms of labor have attracted increasing attention. By investigating attempts to address forms of unfree labor linked to international migration and global supply chains, my book attempts to reveal the extent to which anti-slavery initiatives are linked to the fading legitimacy of contemporary neoliberal global capitalism. Modern slavery involving migrant workers and supply chains is a transnational problem because it crosses national borders. But nation states lack the legal authority, the jurisdiction to deal with it. International law supports national sovereignty and frames it in territorial terms. A state has jurisdiction, the authority to exercise legal power over its territory. Initiatives to combat unfree labor linked to transnational processes do not fit with understandings of jurisdiction tied to the territory of the nation state. Consequently, a thick web of international, regional, national, and local legal instruments has been fabricated to eradicate the global problem of modern slavery. An anti-slavery network composed of key states, advocacy groups, non-governmental organizations, faith groups, trade unions, transnational corporations, and their charitable foundations, and national, international, and supranational institutions and organizations grew alongside it. In this context, the nation state, which used to be the primary governance actor, is not now but one amongst an assemblage of actors, what I call the Global Anti-Slavery Governance Network. To explore the governance strategies of this network, I followed Prava in adopting Halliday and Schaefer's conception of transnational law that places processes of local, national, international, and transnational public and private lawmaking and practice in dynamic tension within a single analytic. I also distinguished law from other forms of social ordering by emphasizing, and I think it's really important to emphasize, law's distinctive institutions and forms and its alignment with state and juridical sovereign powers, coercion. Transnational law also captures the multi-scalar dimension of modern slavery law, since the institutions and organization involved in its production transcend or span the nation state, even though these laws are generally directed at the nation state, since national sovereignty continues to be accepted as the predominant form of legitimate authority in our world. Modern slavery laws exemplify transnational law since they combine international, national, and sometimes regional laws. Modern slavery laws are also an excellent example of how the scalar dimension of jurisdiction operates itself as a technique of governance, one that challenges territorial notions of national sovereignty. Increasingly, states must negotiate with various other agents, such as local governments, international institutions, and transnational corporations that wield power and other sources of law to retain or exercise sovereignty. This partial detachment of authority from territory or deterritorialization requires private actors to enforce border and immigration controls. And here, the United Kingdom is the clearest example. I used to take attendance as a way of surveilling international students. Landlords must check your passport before you can get an appointment. Your driving instructor must look at your passport. I mean, it's your doctor must look at your passport before you can get an NHS appointment. It's internal borders and external borders. Saskia Sassen points to trade and investment treaties as a new type of bordering that allows firms and markets to move across conventional borders with the guarantee of multiple protection as they enter into national territories. What international trade and investment law does is allow firms to rescale, to shift from the national to the international law to enforce contracts. But nations have no similar, or most nations other than the US and perhaps China, have no similar recourse should contractual terms end up harming workers or being unfavorable to the socioeconomic interests of their citizens. States in the global north have begun to respond to this jurisdictional conundrum by enacting laws that require large transnational corporations to exercise due diligence to keep their global supply chains free of modern slavery. In this way, states use corporations residing in their territorial jurisdiction to extend legal norms beyond their territory. This rescaling is part of the game of jurisdiction, in which states, the European Union, the International Labour Organization, and corporations seek to deploy the law to their advantage. Approaching scale in this way helps to illuminate how processes of globalization reconfigure rather than simply weaken state sovereignty. To make sense of this transnational tangle of modern slavery laws, I provide case studies of what can be called transnational modern slavery law. I selected 5 cases because they involve international laws upon which modern slavery is based, the Human Trafficking Protocol, the Treaty for the Abolition of Slavery, the Forced Labor Protocol. They also include key actors in the global anti-slavery governance, key philanthrocapitalists, key states, key international organizations, and they illustrate the scalar interaction of transnational labor law, and they exemplify different approaches, labor, criminal, human rights, immigration, to combating modern slavery. 3 cases focus on the international scale. The first is the United Nations adoption of an international criminal law instrument to define human trafficking. The subsequent attempts by the United States administrations to pin down the meaning of human trafficking, sex was at the heart of this, and the development of a multifaceted approach to the problem. We'll all play a role, so everyone has a role to play. The second is concerned with how Walk Free, a private foundation based in Australia, founded by the iron ore mining magnate Andrew Twiggy Forrest, became a key global governance actor by producing knowledge about modern slavery and promoting business-led forms of governance to eliminate it from global supply chains. He, in fact, ranks, or his organization ranks countries to see how well they do, because you can't trust a country. You have to trust corporations, inspired philanthropy organization. The third case examines the International Labour Organization's use of its jurisdiction over forced labor in the 1930 Convention on Forced Labor to stake a claim in the global anti-trafficking assemblage at a time when its legitimacy was failing because of neoliberal capitalism, and we don't need labor standards. And to steer, the ILO did attempt to steer global anti-slavery policy away from criminal and immigration law towards labor and human rights. Now, shifting from those 3 case studies at the international scale, the 4th case explores the European Union as a site of multi-scalar governance that has led the way by adopting binding region-wide anti-trafficking legal norms that augment the human rights of victims. So it's the human rights approach to anti-trafficking. The final case study, which was the most fun, because how can you not enjoy writing about the United Kingdom under all these people, right? Provides an in-depth account of how anti-slavery governance strategies involving transnational forms of unfree labor in the United Kingdom have changed over time, from New Labour and Blair to Sunak government at the national scale. Although international and transnational legal instruments define the main legal categories of unfree labor, it's nation states that must implement them and give them meaning. Thus, the international norms are filtered through a nation's distinctive cultural political economy. I selected the UK for 3 reasons. First, it was the first country to enact a modern slavery law that combined criminal law with business regulation. Second, as a member of the European Union until early 2020, it was embedded in a multi-scalar legal regime governing human trafficking. And third, it was the second or first most prominent member of the global anti-slavery governance network, especially under Theresa May. Constructing Modern Slavery argues that modern slavery laws are attempts to mediate the escalating tensions around borders and market created by neoliberal global capitalism's reliance on managed migration and free trade as engines of accumulation. The book shows how the United Nations Human Trafficking Protocol was a response to states' fear that the collapse of the Soviet Union, rapid economic liberalization, and increasing globalization were fueling transnational criminal networks engaged in trafficking in drugs, people, and weapons. The global financial crash of 2008, 2009 dealt a blow to neoliberalism's economic credibility, and the pandemic further upended it. Trump struck at the heart of neoliberal orthodoxy, free trade. By providing a genealogy of the amalgam of legal concepts that form transnational modern slavery law, the book reveals how key legal concepts were interpreted and positioned by hegemonic actors in the global anti-slavery governance network, and how a common sense understanding of modern slavery was constructed. This genealogy answers the 5 questions that animated the book. First, how did modern slavery, like really modern slavery, who knew, right, emerge on the global political agenda? Second, where do key actors in the global anti-slavery network draw the boundary between free and unfree labor? What makes, like, where is it, right? Third, how does the multifaceted approach to governing modern slavery, a bit of criminal law, a bit of human rights law, a bit of labor law, a bit of business regulation, a lot of immigration law, how do you keep these different facets from clashing? Fourth, how do attempts to govern transnational forms of unfree labor reconfigure sovereignty? And finally, the book attempts to answer the vexed question, one that continues to perplex me: what makes labor free? Thank you very much, and I look forward to your comments and your questions.
Thanks a lot. I hope that makes sense, because you try to look at your notes, but then you're too interested in what Judy is saying. And I am fairly jet lagged coming back from far away. So first, let me say how much I like this book. And it's been such a treat for me to just read this. So let me congratulate Judy on this wonderful achievement. It's such a rich book, and many of us will use it for the most different projects I teach on global supply chain capitalism and informal labor. And I already see this as being a key part of my curriculum next year. In fact, I'm a bit taken aback as a non-legal scholar. I'm coming out in having been called to comment on this. And I will just, of course, provide the reading that sits on what it is that I do, that is actually mapping global capitalism pathways in the forms of global supply chains. And this is a key debate that we have been dealing with for quite some time, that of the transformation and globalization of forms of labor standards. Now, so the thrust of the argument in the book is this inquiry into how the term modern slavery has come to dominate debates around both trafficking as well as forced labor in global capitalism, particularly connected to global supply chains. And the book really sort of maps the very complex political economy of the term and how different actors have been crucial to the formation of what Judy calls this global anti-slavery governance network as a novel forms of governance by developing their own very strategic thinking thinking about the term. So it's not a functionalist reading on how all these actors see the trajectories taking place, but also reflect both their interplays as well as their own individual trajectory, which is quite a remarkable sort of ability in the book to trace these processes that take place at the same time. So the chapter here produced a sort of very complex and plural, I would call it proto-history of the term, paying attention both to the transformation that occurred materially within the global economy, so that you do see this escalation of particularly exploitative labor relations, and the epistemic pathways towards all of these actors from different perspectives then agreeing on the term modern slavery as a discursive tool proactively used and claimed by nation states and different transnational actors and bodies for different internal projects. Now, multiple actors constituting the global anti-slavery governance network embark in their own trajectory leading to modern slavery as the dominant terms and the better instantiation or the better articulation of the evil to fight. And eventually this trajectory converge in the book. And well, it's de facto, and the book maps how they do that, strengthening a generalized consensus. Now, of course, the analysis go back in time significantly. So I really appreciate the parts of history that trace back actually to the 40s and 50s in how you set some of the legal debate in in which this then will generate. But in a sense, it's 2000, the year where there's the establishment or like this kickoff of the debate having a life of its own, which is, of course, coincides with the Palermo Protocol. And so it anchors it specifically to the globalization period. And the analysis showed the pitfall in the logics of the protocol, which exceptionalizes trafficking as well as forced labor as a sort of market failures or political failures or externality, which of course is conducive to the strengthening of the neoliberal regimes, because he only sees these instances as fringes within what otherwise could be seen as a system that can still work for the many. So from this original sin, if we want, there is a mapping of how different blocks and different powers then contributed to the consolidation of this new consensus, following their own internal logics and objectives. Chapter 1 is great because, of course, deals with the United States as the global hegemon and how it cements itself as a sort of a leader in this new abolitionist movement through a number of different governments that actually takes this stance against modern slavery and, of course, against prostitution, that culminates with Barack Obama's representation of this new abolitionist framework as something which reestablished the dominance of the United States as the leader in the in what can be understood as a global moral order. Then we see what for me was really a interesting and chilling chapter that look at the evolution of corporate-led types of interventions and forms of soft law that also reorganize around the term modern slavery for clear accumulation purposes. So the history of the Walk Free Foundation by Forrest, of course, I just dedicated sort of quite sometimes to your beautiful sort of description of how that comes to be dominant within the debate, and how also the Walk Free project found in the work of Kevin Bale the intellectual tools that were necessary to sort of find its own legitimacy. So you see how this intellectual project and political project then sort of coincide very much in the representation of modern slavery, again as a sort of economic and political failure, but this time one that can cost business a lot, but that instead, if business takes seriously and address, can provide businesses with a lot of new accumulation opportunity. So there is money to be made in being a good guy, and you see really the logics of this particular extreme case that gets replicated in a lot of privatized forms of development that we've seen. So you can compare this, for instance, with even Bono's RED projects, the Global Fund on HIV/AIDS. So there are parallels to be drawn here for future work, Judy. So this is really an instantiation of the commodification of ethics opportunities that this model actually offer. And, you can say more about this, you have a mining capital that talks about modern slavery, right? So it's like having Hannibal Lecter teaching us on veganism. So as a matter of fact, if you look at the work of others, they also highlighted how this commodification of ethics, I'm thinking of the work of Siobhan McGrath and Sammy Watson, they highlighted how this new abolitionism and the formation lead to the formation of a new industrial complex that then also provides new jobs and creates a new burgeoning industry, that of third-party monitoring of people that specialize in teaching us what modern slavery is, how to sort of check out if we can spot the slaves in our daily lives. And you see publication of brochures, materials, and so on and so forth on that. So then we move to a chapter which I also enjoyed very much, which is the one on the ILO itself, which of course since the 70s has been leading on legal instrument to try to sort of focus on the potential labor abuse of multinational corporations, which Judy dedicated time with, particularly the 77 legislation that then will be central to the development of core labor standards. And this chapter also is very interesting because it shows how the ILO, in a sense, have also engaged very strategically with the modern slavery debate to find its own spot in the context of a legitimacy crisis that, of course, is started encountering at the beginning of the neoliberal globalization period, as you know, a UN agency that started counting less and less, as a matter of fact, and that had somehow to reinvent itself. And in fact, the ILO eventually settles within this modern slavery compact, if you want, as the leader on definitions and monitoring of forced labor and its estimates. In fact, the part on estimates, which is one aspect of the book that I enjoyed a lot, it's really revealing. So all of this convergence of focus on modern slavery from different parts and different institutional as well as power networks that manifest itself with an obsession in monitoring and producing data. Of course, the Global Slavery Index is one, but there are like very many nowadays, which always show an increase in modern slavery numbers. So that is in itself is a form of legitimizing this insisting and growing focus on this thing called modern slavery, because it's expanding. We have rising number, and even the ILO number on forced labor that were stalling up to then starts rising together with the rest. So it's quite astonishing the way in which you can read this through the analysis presented in the book. The part on the EU is very interesting. And it focuses on, of course, the move from a more carceral approach to what can be defined at the level of the EU, a more human rights approach, or at least considering the issues of addressing the victims' rights to an extent. Although I would say that within the EU bloc here, I think there are stark differences when we break down these two nation states. The country where I'm from, you have at some point the Renzi government, I'm sure Donatella remembers it, calling for, bombing the boats where migrants were on the shores of Libya to fight against the modern enslavers. So to free the slave, we'll just bomb the boats, or they have to specify that these were supposed to be empty boats, right? So that when they have to call a specific press conference to actually specify this. So still, I agree very much that it's still at the level of the EU legislation is a softer trajectory than the one we see in the UK, considering that quite paradoxically, this focus on modern slavery starts within the project of Global Britain that eventually, will come out as a very anti-migrant project that in fact lead to Brexit, and some of the luckily then not gone through projects that we have seen under the last two administrations before this one. So I think really overall the book really does a great service in trying to complicate the ways in which the modern slavery, modern slavery as a hegemonic terms has come about and establish itself as a consensus, and how neoliberal global capitalism generates laws and regulations which are still what Pister has called the code of capital, but one which is very much negotiated by these transnational logics in which this type of capitalism is embedded. So nobody really manages to get what they want unless they sort of strategize and negotiate with other sort of actors. Now, the book concludes challenging key dichotomies, and using this distinction between the residual and relational approaches to forced labor. And of course, we get a sense that the modern slavery really belongs to residual approaches to an extent, and it's like its main problem lies there. And of course, with the big question that is the unanswerable question that Judy posed in the end. And of course, the message is that it's not via modern slavery that will dismantle the structures of neoliberal capitalism, nor that we can fight unfree labor. So really, for me, this is going to be a tremendous instrument for, teaching on trafficking, modern slavery, and the evolution of labor standards. And I would say that I still have a few questions that I'd like to pose, more to just exploit the fact that Judy is here and to just speak on her wisdoms to do even more. So the first, I just wonder, because this is something that's very dear to me in a sense, it was just traced me back to my first engagement with global labor regulations. And I've been quite involved in early debates on CSR back in the early 2000s. And I think here the genealogy starts from a different place. So instead, I wondered, how do you see the continuities and ruptures between the early or peak CSR phase, was the age of voluntarism, and instead the age of modern slavery in relation to the strategic roles that increasingly states are playing in putting forward forms that at least are like semi-hard regulations like the Modern Slavery Act. I mean, is the rupture, is a continuity, and how we can read it. The second question pertains to the ILO itself, because I enjoyed very much the chapter on the ILO, but my own experience working with the ILO is that modern slavery debate is really a highly contentious and debated issues within the agency. So for instance, the work in freedom program where, I collaborate with and Prabhas collaborated far more than me, they actually have very openly rejected the term and actually published material that expressly say so. So I wonder, when we think about that embracing modern slavery, which echelon do you think of the ILO you came out successful for this project? And then a question pertains to the Modern Slavery Act, because here is represented as a strategic way for the state to translate modern slavery in less soft forms of regulation to then pursue their own objectives of anti-migrant and hardening bordering strategies. But in a sense, if you look at the debate in this country among labor NGOs, has been instead that the act did not have teeth. So this, if you, a plethora of labor NGOs have been lobbying with the legislator for the so-called TISC clause that was considered to be completely useless to instead be strengthened and have elements of criminal negligence. So I wonder what you think of that. And the EU chapter ends with the directive on due diligence. And of course, it's just from August 24, yes, that we wonder what is gonna come out of that. But in a sense, many of us, we wanted to see criminal negligence being centered, and in a way that does not really sort of focus on the global south as potential culprits, like CSR before, but this time on the global north. So is there some leverage there? Ultimately, as I remain a labor organizer, my final question would be, despite all its pitfalls, can the term be reappropriated still? So does the fact that legally is there with all its pitfalls still can be used for organizing and has been? Thank you.
Thank you very much. Thank you, Judy. Fantastic to hear you. Thank you. Oh, it's Crystal. Okay, I start again. Thank you, Judy, for the book. Thank you. It's a privilege to meet you, and Ale as well. Thank you for the remarks, and of course, Prabha for inviting me. I was considering, is it ethical to print the whole?
Yes.
Okay.
I paid for open access. It's
Good.
completely
Like open access, should I kill more trees? But apologies to the trees. But it has been fascinating for me to read the book, and obviously I have been doing research on I call it human rights in supply chains, but this is one of the aspects that I would like to maybe point as well and to ask you about. I'm going to put my timer so I don't rumble too much. And for a while. And the book, so I knew some of the debates that you point in the book and some of the historical developments and how normative frameworks came about. However, it's given me this perspective of now learning to read policy statements and to read policy commitments and even laws and try to understand the angle where it comes from. So try to understand this, make sure that you point of the moralistic argument, the appeal to our morals, the appeal to human rights as a system of protection of dignity, and to appeal to a criminal system that individualizes the perpetrator, which like very clearly puts the blame on the bad guys, and sometimes includes the helpless, no agency victims. So now I found myself rethinking of my own writing, and now every time I pick up some document, I have to think, okay, let me think what the angle that this comes from. And so it's very interesting. So I was finishing the book on my way to the launch to the Global Commission on Modern Slavery and Human Trafficking report, and then when I came back, I know. And then when I came back and I opened it, the first quote, the big quote is, "This is a moral stain on our humanity." So we open up with the moral imperative, and the idea of like we are all to blame for this. We all have a responsibility for this, but we're all the bad guys. We're all to blame. Therefore, no one is to blame because all is an abstract concept. humanity that drives the moral stain, and in itself is actually the recipient of the moral stain as well. And then it continues, modern slavery and human trafficking is the greatest human rights issue of our time. And I thought, oh, so it brings the human rights element, human rights law element. Is this how this is going to continue? You're going to have to read it to see how it continues. Lots of moral appeals and some human rights. So so this is why this idea of, I'm picking up with Ale was saying one of her questions about how useful would it be for us to jump on the bandwagon of this supposed consensus that we have on the use of modern slavery term. You really open our eyes to how this is not really a consensus that has come from a common practice. This is a driven consensus. This is a consensus that have been driven not just by the more vocal organizations on the debate, from the philanthropic capitalism and their charitable branches, but also by all these organizations trying to find their own niche into the debate and into the action, but let's face it as well, trying to find their own funding, because in international organizations as well, and the ILO as well, it's like we need to be part of the programs. And where are the programs coming? They're coming from where are the flows of the money as well to push the action, international organizations' actions, and very much so civil society. And then I would like to pick up on civil society then later again. So therefore, is it useful to have to, let's just decide that modern slavery is the term? And after reading your book and reflecting a lot, I've always been uncomfortable with the term, obviously, and as being an international lawyer, I use the terms that exist. Forced labor exists. Human trafficking exists. Modern slavery doesn't exist as a legal term. So, and I've concluded after my last post-it that no, actually, we should not have the definition, an international legal definition of modern slavery, because of the elements of, I think it's an artificial consensus, and as you rightly demonstrate, brought by all these interests. I think it will just, as we know the processes of international lawmaking, it would only end up being watered down, because there will be a rivalry as to which organization and which sphere of international law prevails. And we had years of negotiations and on the ILO conventions and on the UN organized crime conventions, and we need to build on this, but with the necessary understanding of the great gaps that you point and the clash of legal regimes. I don't think having an internationally defined modern slavery term is going to actually liberate us from the clash of jurisdictions, as in like the legal framework jurisdictions. So that was really interesting in terms of convinced me finally that we shouldn't do it, and that we should then work with the legal terms and the legal avenues that we have, and try to understand what are their own deficiencies and how and where are they manipulated in terms of having pushing us to one way or the other. So then I was thinking on my own work, and I was thinking, okay, well, where are my sins here? And I was like, well, how have I absolutely failed to grasp these tensions before? And I've used modern slavery because it's attractive, because modern slavery makes people
wake up. I mean, people, and as you point out, the way with the new abolitionists have actually picked up on this idea of people needing saving, people not having agency, and us sitting around the table saying we're really appalled that this is happening, and we have this responsibility, whilst at the same time maintaining a legal, an economic, and a social system that is actually the foundation for this. So then I was thinking, okay, so when I try to convince an extra actor that it doesn't appear very much because it's not very totally unglamorous, and the legal system is very boring, which is the public sector buyer, so public procurement. When I try to convince these actors and to somehow try to shape that these are also important elements of because they are important economic actors to come into the debate and to come into the action. I did it on the bandwagon of the UK Modern Slavery Act, and they allowed us to have an anchor, a legal anchor. And I tried to. I've done some trainings with the public buyers in which this nearly 10 years ago, at the very beginning of Section 54 on the reporting on modern slavery. And I'll sit in the room and I'll tell people what the reality of global supply chains were, tell public buyers. So these are the people, think of public buyers are the people that actually buy the table for the university and the chairs. So these are people that buy things. They're not necessarily people that have are concerned with human rights. To try to say this, I found it very difficult to appeal to the moral argument. And in fact, I just for my own ethics, but I just found it really quickly that there was a contra-moral argument that was people in these countries are fine. They are, when I was saying you can't buy, if you buy a t-shirt for £5, someone there is not receiving a fair wage. And I was saying, whoa, that is much higher. Their wages are much higher working for a brand that they will be in the other situations. Otherwise, they'll be begging or whatever, women in prostitution, things like that. So moral argument didn't work, didn't want to do it. So is the legal anchor. So this is an obligation. It's binding. You have a binding obligation to report under the Modern Slavery Act. In this case, it was universities, because universities are semi-public bodies. I mean, they receive public funding. So they are, and they use the public procurement system to buy the goods and services and works. And they are over the threshold of 36 million pounds turnover a year that the UK Modern Slavery Act Section 64 demanded. So therefore, the law served its purpose in this case. Nobody was checking. Anybody had reported. I mean, it doesn't matter that you reported, don't report. But it was the fear of a binding element. And for that, the Modern Slavery Act was useful. And then this brings me to this idea: would it have been more useful? Another piece of legislation that was less dramatic in terms of, appealing to the public. I don't know if I had sat there with the public procurement bill tells you that. Maybe people are not as happy. So the Public Procurement Act. So, and then picking back on terminology, and this is just my last point regarding terminology as well. I read things differently, So now it's like I've always been uncomfortable with terms like end modern slavery, eradicate modern slavery, and if you hear the call for the report, it says, it is a challenge to governments, business, and civil society. Above all, it's a call to action. Act on our recommendations and end modern slavery and human trafficking. So we're going to, just and eradicate. So I was thinking, so a little bit as well, your views on the terminology, because then, you know, the same thing as I've chosen to talk about human rights in supply chains rather than modern slavery in supply chains, unless I really want the journal really wants me to say modern slavery, because if it's not catchy, anyway. But and then I try then to use words such as combating, which is also I'm uncomfortable as well because it's very bellicose, or addressing. So what does addressing bring to the conversation? And this is when we pick up with supply chain and human rights due diligence. Addressing, we can use it to actually encompass, identify, prevent, mitigate, and remedy. And this is where we have the biggest, I think, forgotten element. And remedy, it comes from human rights. So it comes from the link that the human rights law brings to human trafficking and forced labor, which is the right to remedy, considering right holders, so the persons that have been harmed, as those that have standing, both they have their subjects of rights and they have procedural rights to actually be able to claim those substantive rights. So this is why I think the term addressing, and I want, as well as Alice said, now that you're here, you're the authority in this, the kind of like, to what extent does this, is this a good way to approach it? It brings back some of the elements of international human rights law. It can be used to bring some of the elements of international criminal law, because if it's addressing, meaning, you know, remedy, could we have, criminal law, could we have accountability in there, and accountability understood as criminal or civil liability? And therefore, with this, I move to the human rights due diligence, and I absolutely love your chapter on the philanthrocapitalism, and showing us how this is it's structural problem. Unfree labor is a structural problem. That part, it's the one of the basic, or you know, like exploitative labor. One of the bases of global supply chains working. And it's the way global supply chains are you know, that's the nature of global supply chains. The systemic issues are by nature they're obscure, and they are liability avoiding. We'll organize ourselves the way that we can minimize cost, and liabilities is just one cost. Workforce is just one cost. So how do we minimize it to the maximum? And so if capitalism just evolved, shaped the nature of the supply chain, and philanthrocapitalism has shaped corporate social responsibility, is the human rights due just a contestation of that, or is it an evolution of that? And to what extent can human rights due diligence, or has already been co-opted and establishes one more element of the new modern slavery legal system? You know? And I'm always kind of really concerned with corporate capture and corporate co-option, because since the beginning of the business human rights regime, we have mostly the business human rights regime, as opposed to the regime that we had just before Professor Ruggie was appointed as the UN representative for transnational corporations and human rights. Just before, we had a system in which we were trying to find international responsibility for companies for human rights violations. And then Ruggie came, and then now we have a system that makes the business case. And it makes the business case for businesses. So how are businesses better off if they respect human rights, or if they have human rights policies? And how is the state better off, getting more revenue and more taxes? And who's not better off anywhere? The right holders, the people that have been harmed by corporate violations. So to what extent are we at the same risk as human rights due diligence actually being now subsumed by this tide that seems to be modern slavery legislation, and this artificial concept of consensus the modern slavery legislation brings. In a way, I think it's kind of like a blanket that we're putting over a garden full of holes. So we'll just, as long as we sit in the blanket, we can't see the holes. But the holes are the structure of the legal system, of the liability system, the structure of the supply chain, and specifically and the actions of all those in the supply chain, and this includes the public buyer. I always tell them your purchasing practices are as equally responsible for the dynamics in the supply chain and the overall the abuse. So yeah, it's having a bit more of reflection over human rights due diligence, and to what extent human rights due diligence has actually helped bring the stakeholder more into the debate, because we have a lot of research now and some policy commitments and all that consider the role of people with lived experience. And also this has been interesting to hear about the ethical dimension of having of portraying that you have people with lived experience in the as part of the design of your modern slavery strategy or policy. And but at least the human rights due diligence has brought stakeholders and right holders more to the forefront. To what extent they would change at all, or they would engage, made meaningful engagement to actually have them drive the processes, the due diligence processes, is a different question. And obviously after the omnibus, we might just have to just throw it in the bin and just congratulate ourselves for having tried, but and cry. But so yeah, so this is my last thing. Yeah, the last thing that I had about NGOs. Sorry, that I said that I was going to say. So NGOs, beyond the ones that of course you mentioned, and they have the grand names of Free the Slaves and those things. How about the smaller NGOs? How about the NGOs? Even this is even including the ones on the ground. To what extent are we playing into this as well, in terms of like the NGOs have to have their strategic impacts. They need to report to their funders of what on their theory of change priorities and how they have achieved this theory of change in these beautiful trees as well of corporate looking flyers. But yeah, to what extent are we relying on NGOs to represent the stakeholders? And then they also have to play this same game of putting the blanket on top of the whole garden. Thank you very much. Sorry, it's been a bit convoluted. I had too many notes. That actually is a great segue to Marija's comments. Go ahead. Yeah, you can go ahead. Thanks. Yeah, she can. She's unmuted. Go ahead.
Hi, everyone. Can you hear me?
Yes. Yes.
Okay, sorry, I don't see you very well. It looks like you are a little bit in a dark room, but I'll try to gauge by your face yeah. And shall I just start?
Yes, please.
Yeah, okay. Well, thank you very much, first of all, for inviting me to share reflections on Judy's inspiring work among equally inspiring fellow panelists. And I do apologize for not being able to be there in person. It's actually the first week of work after getting back from maternity leaves for me. So unfortunately, I'm not able to travel. And because I'm quite curious to hear answers to a lot of questions and kind of ideas that we threw at Judy, I wouldn't like to take too much space. I quite enjoyed reading the book. I think it's extremely ambitious and rich, and it deserves at least a couple, if not more, readings to take in everything. So the way I understood it is that the book explores how the concept of modern slavery is constructed and mobilized within distinct legal, political, and economic context. And in doing so, the book reveals its complex relationship with global capitalism, state sovereignty, and diverse and often very conflicting governance agendas. So, in my view, the book presents a series of challenges to the modern slavery agenda, and not just in relation to modern slavery as a governance domain or a field of study that we are engaged with, but it questions the very foundations of the political, economic, and legal order within which modern slavery laws, strategies, and research are construed. So I would like to just highlight three key the most prominent features amongst the many, many takeaways you can, and I echo in that respect what has previously been said. So the first is its conceptual work, discussions around ideas such as modern slavery and freedom, revealing key actors and processes that shape them. That's the one key feature. The second one, it's really rich discussion of modern slavery laws and related domains, and its contribution in unpacking as well as analyzing both obvious and perhaps less obvious implications of these laws. And inviting questions sometimes, are these really intentional or just unexpected or unintended consequences? And then finally, it's superb reflection on the relationship between modern slavery and capitalism. So by broadening the lens beyond legal and political to consider modern slavery laws in relation to global neoliberal capitalism. So in my view, I don't know if in my interpretation is correct, it questions the entire modern slavery agenda as a flawed and perhaps even sinister project. And so there are many examples I can draw on to illustrate these points. And I just wanted to hear more from Judy in relation to, for example, you criticize the fact that modern slavery used as an umbrella term is essentially defined by equally contested terms such as exploitation, involuntary, consent, force, fraud, and coercion. So I would really like to know how you approach this conceptual work. Is there, what is the role in law in shaping them? And can we actually find common ground on these ideas? When it comes to modern slavery laws, you talk about the fact that these laws are an attempt to shore up the fading legitimacy of global neoliberal capitalism. And you then contend that labeling abusive practices as instances of modern slavery may not help eradicate them. And it's already been raised here on this panel, the question of, are we actually past the point of thinking that modern slavery, or however we wish to label these abusive practices, are actually possible to eradicate? And on the point of modern slavery and capitalism, and I have to say this is where my expertise really stops, and I haven't done much work on that myself. I have a question there. I mean, I found your critique extremely persuasive and powerful. And when the book argues how the border between free and unfree is contested and an ambivalent artifact of governance, which is a vital step in the normalization of capitalist production, and explains how the extent to which capitalism in Europe and North America, how the modern slavery narrative disguises how the capitalism in these parts of the world was built on slavery and the ideology of anti-Black racism. So what this prompted me to think about is the fact that when I read Orlando Peterson's Slavery and Social Death, a comparative study, in its preface, he notes that one of the most remarkable features of Western civilization is the critical role of slavery at almost all the high points of its development, from ancient Greece to the rise of industrial capitalism. So I kept wondering, well, even though we can say, and you demonstrate that, how modern slavery is sort of entangled with this neoliberal capitalist idea, does the theme actually extend beyond capitalism? Is there something about human nature that, that produces slavery in almost every societal model that we have experienced so far? Is it something that in the human nature that we simply cannot extinguish? So yeah, and then I have a few more questions. I'm not sure. Maybe I should just throw everything there and you choose to focus on whatever you like, and we can obviously talk about this in a different context. But as a reference to your title, Constructing Modern Slavery, I wonder if we, short of dismantling the whole system, what are the reforms from within that it is reasonable to aim for? And, you talk about the case studies that they cover the period of about 25 years from the late 90s to when trafficking was identified as a global problem to September 23. And I wonder if we were to wind back time to 2000, what alternative pathways could have been taken or should have been taken in your view? And finally, potentially the most controversial point, there is a lot of criticism of modern slavery framing trafficking, or however we call it, as in a criminal justice terms, using criminal legislation to tackle it and so on. And I agree with those points. The only problem is that, is criminal law really redundant, or it's just insufficient? Because surely we would never talk about going against, I don't know, rape culture by completely ignoring criminal laws. And so there is much more to be done as a society in educational terms, in terms of prevention and so on, fighting patriarchal norms. But criminal law is essentially like a last resort and the safety net if all of that fails. And just the fact that actually, if we look at statistics, there is the criminal justice aspect is where modern slavery laws have failed to the greatest extent, because there are only hundreds of prosecutions, if even that number in for example in the UK each year, in comparison with estimates of modern slavery. So shouldn't there be some work done in that domain too, or should we completely forget about it? And I understand obviously that you focus on only in the book on labor exploitation and labor migration and so on, but even with regards to these practices, is there a space for criminal law and its improvement? So I think I'm going to stop now, because I'm more interested in what you have to say than to share further thoughts. So thank you very much.
Thank you so much. So I think Judy has a work cut out for her, and you can pick and choose whichever questions you want to address.
Thank you. These were really helpful comments, and you went to the heart of what I was trying to get at, and you asked me the really difficult questions. So I really appreciate this. First off, the book is forensic, not normative, although I do have normative prescriptions. Okay. Secondly, I'd like to acknowledge Janie Chuang, who actually introduced me to Walk Free in a 2015 article she wrote about Walk Free. So she did great preliminary work on this, and she deserves total acknowledgement for inspiring me to look at this area. So I think the comment about criminal law is really helpful, and I'm going to start there, because when I started my activism work back in 1980, just as I was going into law school, I worked in the Violence Against Women movement, and I was the Rape Crisis Center activist. And I spent a lot of my time, my first engagement with the law was to transform rape law into sexual assault law and to increase penalties. But then, as someone who worked with women who'd been raped and sexually assaulted, I spent a great deal of my time trying to persuade prosecutors to drop the charges that they were now instituting because the women who had made the complaints felt so badly treated by the criminal system. And the prosecutors threatened the women I was representing with public mischief. So it wasn't helping them. Was it preventing other things? Under the first conviction around sexual assault and some of the laws that we changed was a young Black man who'd been convicted of raping a young white woman because of an age difference. So one of the things that I've always been worried about is, please tell me, because I don't know, and I've looked really hard, when has criminal law ever helped vulnerable populations? So I've worked with migrant sex workers in Canada, and there are very few convictions of human trafficking in Canada, but there were lots of charges laid because you could get mostly racialized men to plead on procuring and pimping charges because the penalties associated with human trafficking were so hard. And protecting the Asian migrant women that I was working with, what we did was we deported them. And in Canada, to protect migrant workers from sex trafficking, everyone who doesn't have permanent residence and who is coming to Canada to work or as an international student gets stamped in their passport, cannot engage in the sex industry or you will be deported, even the lawful parts. But we don't have data on how many women have been deported because they don't collect the data, because they don't deport them. They say, if we do deport you, you won't be let back. So I just do not know whether criminal law, and I think of Gadd and Broad's work, with they're two great sociologists, criminologists, and they show through interviewing people who've been convicted of trafficking, they're marginal players. They're situational actors. They are not criminal conspiracies of high rollers. So I think that we need to say, when has criminal law helped vulnerable populations? And so far, I've not been able to find it. So if people can, I would love to change my mind on this. I really would. So that's my first thing. So I think criminal law, and I think that the criminal provisions of the Modern Slavery Act have been used incredibly robustly by the UK police against trafficking in drugs under county lines. So if you actually look at the increase in UK residents who are found to be victims of modern slavery, it's children under the age of majority. And the reason why you get them is because there's incredible powers to confiscate property and to ban people from traveling or to certain areas under the prevention orders where you don't actually even need a conviction. So it's juiced up the power of the coercive power of the state that's mostly exercised against marginal people. That really upsets me, right? And it didn't help, though, the women I was working with. It made them more vulnerable and made them not more vulnerable just to state coercion, but to other forms of coercion. So that's one thing. It's hard, you know. I used to, as I say, I used to work in the violence against women movement, and you know, talking about rape was very emotive, and we could get money when we would do that, and especially if someone was brutally raped, we could get more money. It made me feel bad. I left the movement because I didn't think it was dealing with the drivers of the problem. And the drivers of the problem is how we talk about things and what we see are the social causes. And, really, I think rape has a lot to do with patriarchy. And I think we need to talk about heterosexual norms and marriage, equality. And those are really difficult. And I cannot get a lot of money talking about that. I just can't. And I also can't do it quickly. I have to do it over time. And I have to unpack things. So I understand. And I love some of these groups that use modern slavery. The first thing that puzzled me was why groups like Focus on Labor Exploitation, I love that group. I kept asking them, why are you using this frame? And I totally understand it because you can get money to do your work. I totally understand that. But it means that you're also accepting a frame that exceptionalizes and moralizes the problem. And it's hard when you're trying to get by, to do good work, to find an alternative frame, and particularly an alternative frame that threatens people's understanding of the way the world works. So I think the problem is that corporations have way too much power. I'm not keen on Ruggie's due diligence. I like his 2014 paper. He said, really, the problem is limited liability, joint stock corporations, but we can't attack that because people will freak out. Well, that used to be not considered to be natural. In the 1880s, in the United States, limited liability, separate legal personality, these exemptions from basic private law norms were considered as temporary concessions, and they have now been naturalized to the point where in the United States, they have constitutional rights.
God, yeah.
So no, we can't accept language. It will be difficult, but I think we need to actually say, and really, okay, so I'll come clean. My first corporate law course was called Corporation as Criminal. Clearly it influenced me. Right? So it never was natural to me. And I'd go to corporate law conferences and people would say corporations have died. And I want to go, they're not human. They can't. And when they go bankrupt, somehow the directors can save all of their stuff and they have insurance, but the workers are low on the priorities. So I think we need to denaturalize these concepts. And I think human rights due diligence doesn't get to the core. And the core is because what it says, you keep all the power, you get to be bigger and have more money and more power than most states in the world, as long as you exercise due diligence and right holders and stakeholders. And this clearly is my labor law background. I know ways to have people voice, give them unions. So just tell me, supplier, if I'm Primark, I want to know. I'd say to Primark, tell me what proportion of your suppliers have an independent trade union. Tell me what proportion of your suppliers, what's the proportion of male managers versus female shop floor workers? That will tell me a lot about sexual harassment and violence in your place. And, the Global Labor Institute at Cornell has very good output indicators rather than input indicators, because there is utterly not a single bit of evidence that these things work. Not a single bit. So, so how do we do it? So I think it's hard to come up with the language. I was having a glass of Prosecco before the talk today with Donatella saying, how do we find a language to discuss the complexity of what we've normalized in terms of unequal power relations in a world where everything has to be in a 2-second TikTok video. It's really hard. So modern slavery is a good way of doing it, but it's not counter-hegemonic. It really isn't, I don't think. Now, as I say, that's an empirical question. So I would like to be proven wrong. So what alternative pathways? Well, I can, no more limited liability. There goes my pension fund, but I'm prepared to live with that. Personally, it inures to the benefit of the top 2% of the world's population, So get back with the rest of the world? Okay, maybe. So I think that so I understand we live in the real world, and how do we deal with it? So, around rape laws, sexual assault laws, I think, we have to talk to our children. And, it was impossible as a rape crisis advocate to get into the high school to talk to boys and girls about how to treat each other. That was considered like too political, right? So maybe we need to do things like, how do our consumption patterns, like it's true, you get a bit of a rush when you get something new, but it doesn't last, and we all know that. What does last, and we know this psychologically, is effective relations and social engagement. So, but this is not jazzy. It's not sellable. And it goes to the fundaments of how we organize. So I'm not a big fan of human rights due diligence. I have tried with a group of colleagues to say how you can make it worker-centric. So, I do. Are there better ways of addressing it? Yeah, well, let me write some corporate laws. I think, I deal with trust law, corporate law, that stuff. So those are some of the ways that I think of doing it. I think around whether slavery is a really difficult topic, because the definition in the 1926 treaty is chattel slavery, it's property. But there are all forms of slavery that aren't property, and they weren't engines of accumulation. They were clan-based, they were religion-based, they were conquest-based. Yes, we have a habit in context of subordinating groups and treating them badly. I am an optimist. No, optimist is wrong. I am hopeful that people can actually understand that these are bad things. Now, I don't have a lot of evidence, but I do think it's possible. So I don't think modern slavery is really, what they want to do is expand it. If I think of the Bellagio group, beyond chattel slavery, but it's still a part of a carceral apparatus. I really don't want to expand police and state power. I want to expand collective self-determination is what I want to expand. And I think most people are not sociopaths. So most people, when told that they're doing wrong and hurting people, will understand it. Right? Very few people are sociopaths. So we have to actually make the corporate form sociopathic and show how it has these sociopathic tendencies. It's true. It creates wealth, but it also concentrates it. It also destroys our environment. It destroys our ability to live lives that we would like to live. So we need to start talking about those things. And there's other ways of developing, I think, productive power without concentrating it with Elon Musk and Jeff Bezos and can we think of Barclays Bank, right? Who's now going to police bathrooms for us. Great. Like, so I'm not answering all your questions, but so I think a forensic analysis helps us. And I don't think that some of these things are unintended. I think that the Modern Slavery Act was bookended between the Immigration Act of 2014 and the Immigration Act of 2016. And those were incredibly nasty pieces of legislation. And that modern slavery turned the Gangmasters Licensing Authority into the Gangmasters Licensing and Labor Abuse Authority. And it took a carceral turn and started ratting out undocumented migrants, which they did not want to do, but were forced to do, and move them away from the only effective labor regulating agency in the UK. And my fear is that what's going to happen under the Labour government is in protecting the vulnerable, they're going to criminalize the purchasing of sex, which is going to make more women who are forced through constrained choices and few options engage in sex work. And that's what happened in Canada.